This second part of the presentation is about DRIPA and UNDRIP, and a bit of a lesson on constitutional law that I think, again, might be helpful in you understanding how this all fits together. So this is a slide that actually our solicitors have put together as to what went on in 2024. In 2024, the government was doing some low-key consults on amendments to the Land Act in order to implement the Section 7 agreement that they were negotiating with the shishalh. And I don't remember, I don't know if you remember, I think it was in February that came out in the newspaper. And our lawyers at Macmillan, they drew out and brought attention to these proposed amendments. Don Palmer started writing and the media takes off. And apparently Angus Reid poll indicated 94% of British Columbians considered a major change, and most wanted a referendum. The government initially denies the problems, later acknowledges that perhaps they didn't do much of a good job in conveying what was going on here, and they tried to address this through 11th hour consultation. And the government attempted to address the Pender Harbour specific concerns through changes to the dock management plan and use of general authorizations under the Land Act. So
I have a hard time hearing you back here.
okay, I'll try and speak up. All right, so that's basically what went on 2004. But I thought maybe I would give you a bit of a lesson on the constitutional law in Canada. I'm wondering if, did you know, perhaps, maybe you did, that property rights are not constitutionally protected in Canada? They are not. So, if the legislature passed a bill that confiscated my house or your house and indicated there was to be no compensation that would be enforceable, and even if there was some perhaps legal or equitable argument to be made, they could invoke the notwithstanding clause that keeps court out of it. So we're at risk from the government. There are not many things that can hold them back, and property law is not necessarily protected. So if you're hurt by one of these decisions that is made by the government, say if you're the outfitter, a trapper, hunters, people in the tourist business who are hurt by some of these decisions that are made, ranchers using leased land and what have you. The fact that you may suffer a financial loss is not necessarily going to be protected. So you have to understand we live in a parliamentary democracy, and I would argue that perhaps we live in a parliamentary dictatorship if you put through, or if we vote in a majority government, because there's no stopping them. They can legislate whatever they want, which and I guess the major point of this is that they say, well, you can always go to court. Well, the court can't save you from this. Like, if the legislature decides to take my house away, I would try to go to court. Probably that's where I'd resort to. But the court would say, well, the law is clear. This is what the legislature voted on. Sorry, thanks for coming out. You can't say, well, it's not fair, or I don't like it, or whatever. That's the way it is. They have limited ability to set these things aside. So going further, the federal government and the province have lists of areas that they're solely responsible for. It used to be the B&A Act when I was in school, but now it's called the Constitution Act. So, and within their jurisdiction, the provincial legislature or the federal government are supreme as to what they can pass laws on subject only to the Charter of Rights. And again, unless of course they resort to using the notwithstanding clause, which has been used 4 times to date in my research, twice by Quebec, and I can't remember what the other 2 times were, probably Alberta, if I can't remember what they were up to, but anyways, it gives them a carte blanche basically for 4 or 5 years. And as I said, if you go to court, they have limited tools to dismantle and to set aside this legislation. They're not there, the courts are not there to strike down legislation. They have to have a reason. It's just not, if you say, well, it's not fair and I don't like it, it doesn't count, okay? So most of the constitutional cases when I was in school and prior to the charter were simply to complain that either the federal government or the provincial government exceeded their jurisdiction. And that was essentially the only argument you could kind of bring up to them. It was that, well, that's something that the federal government should have been doing, not you. And that was what the break that a lot of people use. But we now have the charter, which we can rely on. But as I indicated to you, I don't think you're going to find protection of property rights in the charter. So there you go. So I would suggest to you that I've got a note here that I envy the U.S. citizens who can recite their Constitution and all its amendments. How many here can recite the Constitution and all its amendments? How many here know what it's even called or where to look for it? We don't. Oh, there you go. We got one of them. Okay, well,
we've all, I think lots of us looked over it over the last 4 years and found out it was useless.
Okay.
We even took weekend courses on it. And at the end, the presenter said, this is useless.
Well, okay, well, I commend you for at least taking the courses on it and finding out, right? Because there's a lot of people out there who haven't done that. So it should come as no surprise that few of us know what Indigenous rights are in Canada or how they are protected in our Constitution, and it's not easy to find. When Pierre Elliott, that other Trudeau, patriated our Constitution back in 1982, Indigenous rights were embedded, I believe, in the last minute, at the last minute, and Section 35 of the Constitution was created to protect Indigenous rights. And so in slide 5, we have Section 35. So that'll be the next one, Christine. So, Section 35, and this is the one that all these people quote as being the law that constitutionally protects Indigenous rights. But basically, it just says the existing Aboriginal and treaty rights, presumably as at 1982, of Aboriginal peoples of Canada are hereby recognized and affirmed.
Great.
Wow. What does that mean? Nobody knows what that means. There's not another 2 or 3 or 4 or 5 pages of legislation that kind of flesh that out. That's it. So, because our politicians have been too afraid to deal with this issue, this simple clause has been interpreted by our courts to mean all manner of things. The courts are not allowed to make laws, but their role is to interpret laws. But where there's a vacuum like this, they get into it, and in my view, they create laws. There are now hundreds, if not thousands of pages, well, there are thousands of pages of jurisprudence, which means case law, interpreting that short sentence. And as Jordan Peterson, I don't know if any of you are aware of him, says legislative cowardice, because of our legislators' failure to get involved in this, has led us to this point. Ma'am, can I get you at the end? Oh, okay. So regardless, this is what we were left with. The courts have taken on the role of interpreting and, in my view, creating new law concerning Indigenous rights. Those rights are constitutionally protected by Section 35 of the Constitution Act. So essentially, we have given the power to decide what the Indigenous rights are to the judiciary instead of drafting legislation outlining the same. Nevertheless, we now have about 40 years of legal precedent which has defined what Indigenous rights are in Canada. The high water mark in this area is, in my view, the Chilcotin decision, which created the doctrine of Aboriginal title. So there's a vacuum here. The courts have filled it. We've had 40 years, and the courts tend to follow previous decisions. They don't always, but they tend to follow it. They stay within the charter. They stay within their lines, and quite frankly, it's a fairly well thought out body of law now, where most people know what the obligations of government are in various circumstances. So, these rights are also, as I said, constitutionally protected and protected by the Charter. So the next thing that happens is UNDRIP and DRIPA. So we have our own we have this lousy legislation, and but we have 40 years of our highest paid, supposedly smartest judges in the world, or in Canada anyway, creating what they think is appropriate law in Canada. But then it comes along the United Nations. They create a subcommittee, which I'm pretty sure, I don't think Canada was involved, to come up with a manifesto which outlines the committee's view on what Indigenous rights around the world should entail. They do this without considering the laws that are in place in their member countries, and so they come up with what our courts have called an aspirational document called UNDRIP. Everyone in this auditorium should read UNDRIP. It's not a very difficult piece of legislation to read. And so, for whatever reason, and I think Canada was under some pressure to adopt UNDRIP, and they have adopted it as law in Canada. So I believe it's been adopted in every province, and certainly in Canada, and it's certainly in British Columbia. So, we've now got some new law that we've imported from the United Nations. What does that do? So we've taken a one-size-fits-all manifesto developed by the UN and made it law in this country with regard to, without regard to our current laws and jurisprudence, our charter, and all those things. So what I think is probably the most frightening article in UNDRIP is Article 26. And it says, Indigenous peoples have the right to the lands, the territories and resources which they have traditionally owned, occupied, or otherwise used or acquired. So, again, if that was aspirational, and that would be one thing, but to me that is somewhat frightening when you think that British Columbia, 110% of the landmass here has been claimed by First Nations as being their territorial government. So what does that mean? Does that mean that Indigenous peoples are entitled to their land back? That's what it seems, that seems to be the fair or simple reading of that legislation. Now, the courts initially said UNDRIP, which is the United Nations Declaration, is merely aspirational. We may or may not get there, but that's something that we will aspire to. However, in BC, we were not happy with just having an aspirational document such as UNDRIP. So DRIPA was passed in 2019 by the BC legislature. Section 3, and maybe you can go to the next slide, Christine. Section 3 says the government, it mandates the government to bring provincial laws into alignment with UNDRIP. Whoa. So hang on here. So this is our legislature in British Columbia saying, in consultation and cooperation with the Indigenous peoples of British Columbia, the government must take all measures necessary to ensure, now there's a must here, so there's no, it's directive, you can't wobble, you've got to go through with it, and you must take all measures necessary to ensure the laws of BC are consistent with the Declaration. So one would think that that would mean that previous Article 26 would have to be brought into the law here in British Columbia. That's this. Quite frankly, when I started reading this starts to scare me. So, Section 4 of DRIPA requires the province to implement an action plan, which has been happening since 2019. And you should look it up. I know I've been told that there are bureaucrats that have been working for the last 5 years, redrafting laws to bring them into conformity with UNDRIP. And there is an implementation plan, and I'm going to show you a slide from that later in my talk here. So they are doing this. They're doing it in plain sight. If you bother to look, it's there. The politicians aren't telling us anything about it, but they are moving in this direction. So then, the area that's giving us the grief at the moment, or at least Pender Harbour the grief at the moment, is Section 7. And it's a fairly short section, but it allows the government to enter into agreements with Indigenous governing bodies to enter into a joint statutory decision-making power on those issues outlined in whatever agreement it is that they have going at that time. This is where, again, we get into the situation of the difference between shared and joint decision-making. This is joint and requires the consent of both. The subject matter here is not defined, so it could be any statutory decision that has to be made in the province. And it's not confined, there's nothing confining it, and they must agree jointly. So, what does that mean? The government does not like to use the word veto. They hate the word veto. They say it's not a veto. Well, the way I explain what joint decision making is that you have to think of a joint checking account with 2 signatures required. And if you want to use it as with your husband and your wife, you would never say that your wife and your husband has a veto, but unless they sign the check, you're not getting the money. So essentially you need consent and you need prior consent. And in this situation, the government does not have the hammer. You'll recall under the foundation agreement, they retained the statutory decision-making authority. This specifically says that the government will no longer be the sole, not owner, they will no longer solely have the statutory decision-making power. It will be shared with First Nations. So, and I'm not sure what happens in a situation of stalemate. I would think that nothing gets done, but I don't know exactly. So our situation in Section 7, Pender Harbour Section 7 agreement deals with docks in the SWIA. And I asked one of the bureaucrats at one time, this is pretty important legislation. Are docks in Pender Harbour the most important issue that our Indigenous brothers and sisters are facing now that they want to have joint decision-making power on these docks? And I wasn't really given a very good answer, but the thing is, and I think the reason that we've been chosen is that who cares about docks in Pender? Nobody. You guys don't care. You care about your docks, I'm sure, but people that just don't care unless this is in their face and unless it's affecting them. And so no one cares, and that's why I think they've been pushing this. This Section 7 agreement that they are negotiating is the first of its kind in British Columbia and perhaps in the country. We are the cutting edge of Section 7. Others will say that there have been other Section 7 agreements reached, but they deal with mining leases where you have a mining company, a First Nation, and the government, and they're all got their hands out, and they're all going to make money. Well, yes, that worked really well. And they're all holding hands at the same time. No one is holding our hands, and in fact, we've been entirely left out of the cold. By statute, they're required to say who they're going to consult, which they've named us, Pender Harbour. We have not been consulted once yet. We've written them a letter asking them 21 or 22 questions, no results. And that's what's happening. It's going down. There's been no consultation whatsoever. Their excuse is that they're not quite ready. Our lawyer, or our letter says, by the time we get to this, the cake is going to be half baked. So that's where we're at this point in time. It's our impression, and I believe it's been said by the government, that our agreement will be used as a template for other agreements around the province. There will be no limit to the subject matter. And for us, again, this is, I don't want to keep getting back to docks, but for us in a dock situation, it became clear to us that it didn't really matter what the dock management plan said if we had to deal with the First Nation with a veto every time we wanted to renew. It just doesn't matter anymore. We felt we had to get this cleared up. So we felt that there was no choice to bring proceeding in court. We obviously would have preferred the government dealt with this in another way, but they seem to be launched in this direction. I've already talked about the court having limited power to intervene, but we did file the petition in I thought it was in September, and I'll go through the legal arguments that we've made in the brief. If you go to our website, the entire petition is there. It's about 45 pages long, and it does go through a lot of history, and it's actually quite educational, if you will. It gives it quite a good background of how we got to where we are. These are the grounds that we filed our petition on. What we're saying, there's four grounds. The first one is that the DRIPA, giving statutory decision-making power to First Nation, is inconsistent with Aboriginal rights provisions in Canada's Constitution, Section 35. So essentially what we're saying is that UNDRIP and DRIPA, like they're not consistent with how our courts have dealt with Indigenous law and how it's evolved. So it's incongruent. It doesn't jive together. So it doesn't work, and it shouldn't be protected by the Constitution. So the next thing is that this DRIPA also tries to dictate what laws future governments must pass, and there's a dictum or a legal precedent that you can't bind the hands of a future parliament. You can't hold parliament to pass only certain laws. That's not appropriate. The new legislature, the new parliament can pass, should be able to pass whatever laws they want, but this attempts to keep all laws in conformity with UNDRIP. So we feel it's unconstitutional on those grounds. There's also been an infringement of the charter right to vote, in that decisions are being made by Indigenous governments, and of course those are people who none of us have been able to vote for, and we believe that to be an infringement of the charter. It's basically they're able to issue edicts without, and we're not able to, they're not accountable to us. We don't vote for them, but they can still rule over us. The last one talks about the DRIPA relates to matters of federal jurisdiction, and that there cannot be a patchwork or there will be a patchwork of Aboriginal rights among different provinces. The Constitution Act sets out that they call them Indians, not Indigenous people in the Act, but Indians is exclusively federal jurisdiction. This clearly deals with Indians, and so it should not be allowed to stand, because it's something that the federal government should be legislating on. And the argument also is that it wouldn't be right to have different laws for Indigenous peoples in BC as opposed to what they're doing in Alberta, Newfoundland, and the rest. So those are the grounds in short form. The fourth slide. These are our concerns. The government must be responsible to all people in the public interest. We question whether the Shishalh Nation gets to govern non-Indigenous people. Does it have to govern in the public interest or in its own interest? Judicial review, which the government often cites as a remedy here, will not work here under these circumstances. dock management plan that I've talked about quite a bit today has no legal effect. It's merely a policy and protects nothing. The general authorizations that they're issuing these days are not terribly clear and can be changed at the whim of the government. Again, our concern is that the Shishalh Nation will continue to have a veto on all future applications for foreshore terms, tenures rather. So if we're at the risk of them just saying no to any foreshore tenures or renewals of those tenures. So one more slide. I just found this document about 2 days ago, and it's part of the implementation package that the government has put together, and it's put together by the First Nations Summit and by Union of British Columbia Indian Chiefs, and the rest, Assembly of First Nations, and lo and behold, the British Columbia government. And this is supposed to be a shared vision, guiding principles, goals, and objectives. So these are all shared visions of the government and the First Nations. And number 6 of this document says, First Nations have existing rights to the lands, territories, and resources which they have traditionally owned, occupied, and used. That's almost verbatim what is said in UNDRIP, so that's now in documents that are endorsed by our BC government. An Aboriginal title, which includes economic and jurisdictional components, is not dependent upon further court declaration or recognition by the Crown for its existence. Okay, so Aboriginal title is something that came out of the Chilcotin decision. Basically, it says that if the First Nation can prove these tests, and I don't know them off the top of my head, so I can't recite them, but they put out a test that if you come to that, the court will grant Aboriginal title to the First Nation for those lands. And they would ask, well, what does Aboriginal title mean? Well, it means it trumps fee simple. It trumps any tenure that you might have. And as far as I'm aware, the only case where they've granted it is in the Chilcotin decision. And however, having said that, recently, then what's been in the news is Haida Gwaii, where the government basically gave Haida Gwaii to the Haida. And when I first heard it, I thought, well, I guess if it's all Haida up there and they're going to get it anyway, I don't know. I didn't really think too much about it until I heard that 50% of the population in Haida Gwaii is non-Haida. So, and that there's fee simple properties on Haida Gwaii. So, quite frankly, once again, instead of putting United Nations law and crushing it into our existing Canadian law, what they've done is they've taken Aboriginal law and crushed it over property that is already governed by fee simple and First Nations and what have you. And so now they don't know. They've said, well, it's not going to affect fee simple land. And I'm going, well, why not? I mean, maybe they'll be able to keep their title, but who are they going to be able to sell their property to? Who's going to decide what their zoning is going to be on their property? And you can just think of all of the things, like you might be able to retain your property, but how would it affect you if they did it here? And certainly I've thought about it, about what if they did the same thing to us on the Shishalh Peninsula down in Pender Harbour. And if they can do it there, what makes you think that they can't do it here? So, again, another thing to be scared about. So my ask, I'm just about done. My ask here is that I'd like you all to pay attention to what's going on at the moment in the news. I believe there may be a big announcement tomorrow. I'm speaking to the Business Council of British Columbia tomorrow, and following me is supposed to be some big announcement relating to the Shishalh Nation and their foundation agreement, so we're kind of wondering what that's all about. Nobody knows, and we certainly haven't been consulted once again. I would ask that those of you that are not educated on these topics, that you read up on them. Don't believe anything I've said to you. You should read up on them. Read UNDRIP, read DRIPA, and realize that these are our law right now. Talk to your neighbors and friends and relatives. Get to know your MLA and let them know your concerns about this. Get involved and let your voice be heard. It's my view that we need to get out in front of this before it goes any further, because I think once it's entrenched, it's going to be that much more difficult to get it set aside. It may be, so the other thing is that I would encourage you to donate to our legal fund. We are not independently wealthy people. We're relying on legal fees from all over the province and industries all over the province, and we can use all the help that we can get. And quite frankly, our Pender Harbour is a population of about 3,000. We alone don't have the funds to finance this litigation to its end, so we're relying on help from others. And it's been good so far, but we're only just starting. And then I guess the last thing I have is, I've always thought this was a good, when I'm on these small committees in Pender Harbour, Margaret Mead said, "Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it's the only thing that ever has." So I believe that it's up to us, it's up to you discussing this with your MLA and trying to get your point across as to what's fair and what we think should happen going forward. So that's all I've got for you tonight.